Thank you, everybody. The legislative hearing by the Subcommittee for Indigenous People will come to order. The subcommittee is meeting today to hear testimony on 3 bills, H.R. 312, H.R. 375, and discussion draft of the RESPECT Act. H.R. 312, sponsored by Representative Bill Keaton, the Mashpee Wampanoag Tribe Reservation Reaffirmation Act reaffirms the trust status of the lands of the Mashpee Wampanoag Tribe in Massachusetts. H.R. 375, sponsored by Representative Tom Cole, would amend the Indian Reorganization Act of 1934 to give the Secretary of Interior the power to take land into trust for all tribes, regardless of the date of the tribe's recognition. This is known as the Clean Carcieri Fix. The discussion draft of the RESPECT Act, sponsored by Representative Rahul Grihava, Chairman Rahul Grihava, codifies tribal consultation procedures for all federal agencies to follow. It establishes standards, guarantees that meaningful and effective tribal consultation occurs when federal agencies are planning activities that impact tribes, and provides judicial recourse for tribes when agencies violate their consultation obligation. Under Committee Rule 4F, any oral opening statements at hearings are limited to the chairman and the ranking minority member. Therefore, I ask unanimous consent that all other members' opening statements be made part of the hearing record if they are submitted to subcommittee clerk by 5 p.m. today, or the close of the hearing, whichever comes first. Hearing no objection, so ordered. I now ask unanimous consent that Representative Cole, Representative Keating, and Representative Gosar, who is not here but will be joining us, have permission to sit on the dais and participate in the hearing if they wish. So ordered. Good morning to you all, and a warm welcome to all of our witnesses here today. Today, we are examining legislation that addresses 2 issues at the heart of tribal sovereignty and self-governance: tribes' ability to take land into trust and tribal consultation. The acquisition of trust land for the benefit of Indian tribes is essential to tribal self-determination, economic development, and the protection of tribal lands for generations to come. This is why the Carcieri Supreme Court decision has been so disturbing to Indian country. For over 8 decades, the Department of Interior, under both Republican and Democratic administrations, had consistently construed the Indian Reorganization Act to authorize the placement of land into trust for any tribe, so long as that tribe is federally recognized at the time of the trust application. However, in 2009, the Supreme Court held in Carcieri versus Salazar that only tribes that were under federal jurisdiction in 1934 were eligible to place land into trust, effectively creating a 2-tiered system for trust land acquisition. The uncertainty caused by this decision continues to threaten tribal sovereignty to this day. A legislative fix is necessary to ensure that we are fulfilling one of our country's most important obligations to Indigenous communities. H.R. 375 is that fix. I want to thank the sponsor of the legislation, our colleague from Oklahoma, Mr. Cole, for introducing this bill and for testifying here today. Enacting 375 would restore clarity and stability for all federally recognized tribes, regardless of their date of recognition. One contrary consequence that many tribes have faced in the aftermath of the decision is frivolous lawsuits on land that they have had in trust for years. One such tribe is the Mashpee Wampanoag of Massachusetts. Like many tribes, for centuries after Europeans came to this continent, the Mashpee were intentionally and systematically rendered landless by state and federal governments. They have fought long and hard since that time to reestablish that which was taken from them, a homeland. They did that just in 2015, when the Interior Department approved their application to take 320 acres into trust for the tribe. In 2016, however, a suit was filed in federal court that challenged Interior's action based on the Carcieri decision. Although the Obama Department of Justice initially sought to defend Mashpee's land in an appeal in May 2017, the Trump DOJ inexplicably withdrew that appeal. Then, on September 7, 2018, Interior issued its first Carcieri decision, stripping a tribe of its reservation, resulting in the removal of 2015 trust land from the Mashpee territory. The legal limbo imposed by this decision has left the Mashpee on the brink of dissolution. The Mashpee's relationship with the federal government is one of the oldest in the United States, dating back to when the Pilgrims landed at Plymouth Rock. I think it's a particularly sad statement that 400 years later, they still have to defend against the attack on their lands. H.R. 312 would affirm the trust status of Mashpee lands and ensure that these types of attacks on their homeland do not continue. I want to thank the sponsor of this legislation, the gentleman from Massachusetts, Mr. Keating, for being here to testify. Finally, we come to the issue of tribal consultation. All of us here understand the importance of ensuring effective, meaningful consultation with tribal governments before the federal government takes actions impacting tribal communities. However, time and time again, we have heard from tribes about the problems with the current consultation framework, namely that there really isn't one. Consultation processes and procedures differ widely from agency to agency and sometimes from region to region within the same agency. The result is a myriad of consultation procedures of varying effectiveness and sometimes no meaningful consultation at all. Consultation requirements should be clear and should have the force of law. The RESPECT Act would codify a process for government-to-government tribal consultation and give tribes legal recourse when they are denied access to this process. I want to thank Chairman Grijalva for his tireless work on this issue, and I look forward to discussing the proposed legislation with him and our witnesses. I would now like to recognize the Ranking Member, Mr. Cook, for his opening statement.
Thank you, Mr. Chairman. I want to apologize for being late. I was on the way over, and I got run down a crosswalk by some guy with Alaskan plates. So I continued my journey, hobbled up here. And so once again, I am always certainly cognizant of the time constraints. As you mentioned, the subcommittee will receive testimony today. 2 bills, draft bill. And from the outset, I want to express my support for H.R. 375 and H.R. 312 because they bring all tribes, including the Mashpee tribe, onto an even footing with all the other tribes for having land acquired in trust under the Indian Reorganization Act of 1934. Section 5 of the Indian Reorganization Act, and I got in here, the IRA, I'm sorry, the Irish in me. I think that's a very dangerous phrase, but I'll go with the flow. It authorizes the Secretary of the Interior to acquire any interest in land or water to be held in trust for an Indian tribe now under federal jurisdiction. 2009, the Supreme Court resolved a lawsuit resolved by Rhode Island Governor Carcieri, holding that the tribe now under federal jurisdiction refers only to those tribes that were under the federal organization jurisdiction of the United States when the Indian Reorganization Act was enacted in 1934. H.R. 375, sponsored by Mr. Cole, would reverse the Supreme Court ruling through an amendment to the Indian Reorganization Act. His bill would provide that any federally recognized Indian tribe, regardless of its status when the IRA was enacted in 1934, may have lands taken in trust under the authority of the subject act. This bill creates certainty for tribal government that wish to use their lands for economic development and other tribal purposes. The second bill, H.R. 312, sponsored by our colleague from Massachusetts, and he's still gloating over the 2 wins that they had in baseball and football, but we won't mention that. Mr. Keating looks to ratify and confirm previous actions made by the Secretary of the Interior during the Obama administration to acquire land in trust for the Mashpee tribe, just as Mr. Cole's bill aims to do for all tribes. The Mashpee tribe, one of 2 federally recognized tribes in Massachusetts, was granted federal recognition by the Department of Interior in 2007, but its status has since been challenged due to the ruling. These 2 bills, 375 and 312, would put many tribes on the pathway to better health, better education, and greater self-reliance, a goal shared by tribes, by the federal government, and I hope by everyone in this room. Federal government has charged itself with moral obligations of the highest responsibility and trust towards tribes, as quoted in the Seminole Nation versus the United States, 1942, and Congressman Young, I was not born that, I was born much later, and I won't share that information with you. By allowing the impacts of the Carcieri decision to stand without remedy for a decade, Congress has abandoned the trust responsibility for many tribes. By allowing the impacts of that decision to stand without remedy for a decade, Congress, both Republicans and Democrats, have abandoned that trust responsibility for many tribes. The solution here demands more than grandstanding. It's a complex issue. Boy, I could underscore that demands our attention and diligence to get it right. Taking land into trust is perhaps the most important tool for trust to improve the lives of their members. It provides to them the modicum of the resources that the United States took from them through the deliberate policies of discrimination, forced relocation, and other humiliations during the darkest periods of American history in tribal relations. The final bill is one that is sponsored by the chair, and this would prescribe procedures between federal agencies, and I'm being gavelled down, I guess. Thank you, Mr. Chairman, for my abbreviated remarks.
I apologize, Ranking Member Cook. That was just a jest, in jest.
I was just going to praise the chair.
Oh, well, we don't need that. Thank you, Ranking Member Cook. Now I'd like to welcome distinguished members of Congress who wish to testify on the bills they have sponsored. First, I welcome our colleague from the great state of Oklahoma, Representative Cole, to speak on his bill, the Clean Carcieri Fix, H.R. 375. Next, we have the honorable gentleman from the Commonwealth of Massachusetts, Representative Keating, to testify on behalf of his legislation, H.R. 312, which would reaffirm and protect the Mashpee Tribal Reservation. And last, by no means least, the chairman of the Natural Resources Committee, Representative Grijalva from Arizona, who will speak to his proposed tribal consultation legislation, the RESPECT Act. Thank you, sirs, for your testimony. Mr. Cole and Mr. Keating, you're welcome to join us on this dais and ask questions of the witnesses, but I know you have a very busy schedule, so we understand if you must leave us. And I would now like to recognize Representative Cole for 5 minutes.
Thank you very much, Mr. Chairman. Chairman Gallego, Ranking Member Cook, and members of the committee, thank you for giving me the opportunity to testify. I appreciate you holding today's hearing on H.R. 375, legislation that would amend the Indian Reorganization Act of 1934 and reaffirm the authority of the Secretary of the Interior to take land into trust for Indian tribes. Between the passage of the Dawes Act in 1887 and the passage of the Indian Reorganization Act in 1934, the Indian land mass in the United States shrank by 86 million acres. Since the enactment of that law, the Department of the Interior has taken back only approximately 9 million acres of land into trust status. Tribes have used their trust lands to build community facilities such as schools, health centers, and housing that serve their tribal members. This land is also used for tribal enterprises and promotes economic development in communities that are often underserved and poverty-stricken. In 2009, the Supreme Court of the United States overturned long-existing precedent in its decision on Carcieri versus Salazar. The Supreme Court ruled specifically that the Secretary's authority to hold land in trust for tribal governments under the Indian Reorganization Act was limited only to recognized tribes, quote, now under federal jurisdiction, unquote, with the word now, meaning June 18, 1934, the date of the enactment of the Indian Reorganization Act. Previously, lower courts viewed the word now as the instant when the Secretary invoked their trust acquisition authority. However, the Supreme Court reversed the lower court's ruling on how the term now, quote, now under federal jurisdiction, Section 19 of the Indian Reorganization Act, was to be interpreted. It found that the phrase refers only to those tribes that were under the federal jurisdiction of the United States when the Indian Reorganization Act was enacted in 1934. As a result of the Carcieri decision, the Secretary of the Interior may no longer use the Indian Reorganization Act to acquire trust land for any post-1934 tribe without specific authorization from Congress. Because the Secretary has acquired lands in trust for dozens of tribes recognized after 1934, the Carcieri ruling calls into question the validity of the trust status of such lands and jeopardizes their immunity from state and local taxation and regulatory jurisdiction. Many tribes have been forced into court to defend the status of their trust land, costing them millions of dollars and compromising their investments and jurisdiction. H.R. 375 would amend the Indian Reorganization Act and clarify the language of the Supreme Court ruled upon by striking the term I previously referenced and inserting the words, quote, effective beginning on June 18, 1934. It would also amend the statute language from, quote, any recognized tribe now under federal jurisdiction, unquote, to, quote, any federally recognized Indian tribe. The modest changes clarify that the Secretary does have the authority to take land in the trust for any tribe that the federal government has recognized. As a member of the Chickasaw Nation and co-chair of the Congressional Native Caucus with my good friend, your fellow committee member, Representative Howland, I commend the subcommittee for moving forward with this legislation and certainly its willingness to address this important issue. So thank you very much, Mr. Chairman, and prepared to answer any questions at the appropriate time.
Thank you, Representative Cole. Now we'll have Representative Keating from Massachusetts for 5 minutes.
Thank you, Mr. Chairman. And in terms of your opening remarks, Ranking Member Cook, don't be sorry for the Irish in you. It's a badge of honor. Thank you, Mr. Chairman. Thank you, Chairman Gallego, Ranking Member Cook, and the distinguished members of the committee for inviting me to speak today about H.R. 312, the Mashpee Wampanoag Tribe Reservation Reaffirmation Act. As you know, this bipartisan legislation would direct the Department of the Interior to keep 320 acres of Mashpee Wampanoag land in southeastern Massachusetts in trust as federally recognized reservation land. The Mashpee Wampanoag tribe has called southern New England their home for more than 12,000 years. So many of us know them as the tribe that welcomed the Pilgrims to Plymouth, Massachusetts for the first Thanksgiving. Sadly, so many Native Americans, like so many Native Americans, the Mashpee Wampanoags have experienced a long, tragic history of injustices that continue to this day. After a decades-long legal battle, the Mashpee Wampanoag tribe finally won federal recognition from the Department of the Interior in 2007. This distinction granted long overdue access to important federal resources that are now vital to the tribe's existence. The tribe leverages its federal support to provide adequate housing, offer employment opportunities, and operate numerous essential services, including law enforcement, native language learning, pre-K education, healthcare, counseling, and many other things. In further recognition of their important place in our history, in September 2015, the Department of Interior supported the Mashpee Wampanoag tribe, their plan to acquire land in Taunton, Massachusetts, with the goal of placing it into a federal trust. However, as this committee understands better than most, the Supreme Court's interpretation of the Indian Reorganization Act of 1934 and Cashieri versus Salazar resulted in great uncertainty for Native American tribes around the country. Like many others, the Mashpee Wampanoag tribe's federal recognition was placed at grave risk. Additionally, in September 2018, the Department of the Interior decided to reverse course and ended support for the Mashpee Wampanoag tribe in an ongoing legal challenge to the status of its Taunton reservation. This reversal has exposed the tribe to the unprecedented fate of having their land taken out of federal trust. To this day, they remain the only federally recognized tribe in New England for which Congress has not acted to create and protect a reservation. It is for these reasons that H.R. 312 is so important. This legislation draws on precedents set by this House in both the 113th and 115th Congress to lift the Cashieri cloud over Mashpee Wampanoag's tribe's existence and direct the Department of Interior to consider them fully recognized for the purposes of the Indian Reorganization Act. This would ensure the Department can retain the Mashpee land in trust without issue or challenge, providing safety and security at a time when the tribe finds itself on the brink of extinction. Under normal circumstances, legislation like H.R. 13 would pass the House without a hint of opposition. In the 113th Congress, the Gun Lake Trust Land Reaffirmation Act received overwhelming support by both parties. In the 115th Congress, the Thomasina E. Jordan Indian Tribes of Virginia Federal Recognition Act passed unanimously by voice vote. Both of these acts became law, each under a different president's administration. Unfortunately, due to economic factors outside the tribe's control, the Mashpee Wampanoag status has become needlessly contentious. Put simply, the state of Rhode Island has decided that protection of their casino revenue is more important than the long-term existence of the Mashpee Wampanoag tribe. The opposition to H.R. 13 is grounded in the belief that Rhode Island's decision to build near the Massachusetts state line should grant them territorial rights that extend over that border and into the Commonwealth of Massachusetts. Nothing in this legislation grants the tribe any special permissions pertaining to the construction of a casino. H.R. 312 would not grant the Mashpee Wampanoag any new or special rights. It merely ensures that the Mashpee Wampanoag tribe is treated equally alongside other Native American tribes and is no longer vulnerable to having its land taken out of trust. It's important to note that the Massachusetts state government has already approved a casino development in the region, regardless of whether the tribe operates it or not. Rhode Island knows full well that a private developer has bid for a separate project just up the road from the tribe's reservation. A casino's coming to southeastern Massachusetts no matter what. So why deal a death blow to this tribe? Mr. Chairman, Mr. Ranking Member, thank you for this timely hearing. As you know, the Mashpee Wampanoag tribe finds themselves in an extremely dire and uncertain situation as the federal recognition sits in limbo. Time is of the essence. Secondly, I ask for unanimous consent to introduce into the record 54 documents in support of H.R. 312, including a letter from the entire Massachusetts House delegation urging support for an issue entirely within Massachusetts borders. These materials also include support from individual tribes from around the entire country, pan-tribal coalitions, local government, local business organizations, and members of the Massachusetts State Legislature. To paraphrase one of the letters in these materials I placed before you, our country would not be what it is without the help of the Mashpee Wampanoag tribe providing the Mayflower passengers help nearly 400 years ago. Today, we must do our part to honor the Mashpee Wampanoag legacy and take one small step towards returning the favor. I thank the committee and I yield back.
Thank you, Representative Keating. And now we'll have Chairman Raul Grijalva.
Thank you, Mr. Chairman. The goals of the legislation is simple and straightforward. Effective, meaningful tribal consultation as a matter of law. This has been a top priority since I came to Congress. This bill originally came out of frustration, the frustration and obstacles that tribes have faced when it comes to agency actions that affect tribes. It came out of conversations and meetings I had with tribal leaders over the years, where I heard of the issues that arise between tribes and the federal government when tribes are not respected as the sovereign nations that they are. Congress has never established standards for the federal government to follow when it takes actions that affect tribal communities, despite the fact that this is part of our trust responsibility. As the chairman stated, the current lack of unified framework has a myriad of consultation procedures, each different from agency to agency, and the process is even more cumbersome when multiple agencies are involved. And much too often, federal agencies have already decided on a course of action and then consult with tribes by simply notifying them of that agency decision. Much of the confusion and conflict between the federal government and Indian tribes can be traced back to a lack of clear guidelines for meaningful consultation. The legislation sets forward detailed procedures for the timing, format, implementation, and documentation of executive agency consultation with tribes. It also protects sensitive tribal information, such as location of sacred sites and other details of cultural and religious practices, and instructs agencies to recognize tribal sovereignty and minimize agency involvement in tribal affairs. Finally, it provides judicial recourse for tribes when federal agencies fail to fulfill their consultation obligation. Promoting meaningful government-to-government consultation will create long-lasting efficiencies, reduce project delays, help avoid legal battles, and help fulfill the legal obligations of the federal government by ensuring tribal nations have a voice at the table. There is a reason this is a discussion draft at this time. I want to hear from the experts on the issue and in Indian country on the best way to implement this proposal. As I have said before, the best ideas for Indian country come from Indian country. And as such, I look forward to a good discussion on the legislation, to hear the thoughts and ideas from our witnesses and others. I want to thank you, Mr. Chairman, for bringing this item up, and I yield back the remainder of my time.
Thank you, Mr. Chairman. Thank you, gentlemen, for your testimony. Mr. Cole, Mr. Keating, you're welcome to join us on the dais and ask questions of the witnesses, but I know you have a busy schedule, so we understand if you must leave us. Give them a minute. Will the next panel please take your seat? Our first witness for this panel is the Honorable Jessie Little Doe Baird, Vice Chairwoman of the Mashpee Wampanoag Tribe. Next is Mr. Kevin Washburn, Dean and Professor of Law at the University of Iowa and former Assistant Secretary for Indian Affairs at the U.S. Department of Interior for the Obama administration. Then we have Ms. Colette Rotel, Director of the Indian Law Program and Professor of Law at the Mitchell-Hamlin School of Law. And finally, we have Ms. Clare Richards, Executive Counsel to the Governor of Rhode Island. Let me remind the witnesses that under our committee rules, they must limit their oral statements to 5 minutes, that their entire statement will appear in the hearing record. When you begin, the lights on the witness table will turn green. After 4 minutes, the yellow light will come on. Your time will have expired when the red light comes on, and I will ask you to please complete your statement. I will also allow the entire panel to testify before we start questioning the witnesses. The chair now recognizes the Honorable Jessie Little Doe Baird to testify.
Good afternoon, Chairman Gallego, Ranking Member Cook, and distinguished members of the subcommittee. Greetings and thanks also to our great champions, Representatives Bill Keating and Joe Kennedy. Natasuis Jesse Kwanikwais, Nutomas Masipi Wampanoag ka nin sonkash kwata Masipi wataki mowanyat. My name is Jessie Little Doe Baird. I am from the Mashpee Wampanoag Nation, and I am the Vice Chairwoman for the Mashpee Wampanoag Tribe. I hold a Master of Science in Linguistics from MIT, and I'm also a 2010 MacArthur Genius Fellow. I come before you today on behalf of the Mashpee Wampanoag Tribe. My tribe is facing the unthinkable, the disestablishment of our reservation, the collapse of our government, and the loss of many of our public services. Congress has the power to prevent this with the bipartisan Mashpee Wampanoag Reservation Reaffirmation Act. Thank you so much for holding this hearing today. Until 2015, we were the only federally acknowledged tribe in New England without federal trust lands of our own. All others have individual acts of Congress that provide them with reservation lands. In contrast, Mashpee had to ask the Secretary of the Interior to take land into trust for us under the general authority Congress gave him under the Indian Reorganization Act. In 2015, with the strong support of the Commonwealth of Massachusetts, the City of Taunton, and the town of Mashpee, Interior took land in trust for the tribe and proclaimed it as our reservation. However, rather than defending its original decision and litigation challenging it, in September 2018, Interior instead issued a new decision based on a different legal theory that has called into question whether the tribe is eligible for the IRA at all. This creates the very real possibility that our land will be taken out of trust altogether and our reservation disestablished, something that has not happened since the termination era. The threat to our reservation status has had devastating consequences for my people. Without congressional action confirming that the IRA applies to Mashpee, not only will we lose our current reservation, we will never have any reservation. This uncertain status of our reservation has forced us to borrow thousands of dollars every day to keep basic government functions running. We've been forced to lay off 40% of our workforce, and tribal unemployment is on the rise. The tribes had to shut down or severely scale back vital government programs. The tribe had to cut its police force by 2/3 and has drastically reduced tribal court staff. We already have severe housing shortage, and 43 tribal homes under construction right now have been jeopardized by the uncertain status of our reservation. We've lost our federal funding for natural resource protection, costing the tribe an estimated $1.2 million already. We've had to shut down our critically needed addiction treatment service programs at a time when Wampanoag people are 400 times more likely to die of an opioid overdose than non-Wampanoag people in our region. Our internationally recognized Wampanoag language immersion school, Makayasak-Wiku, is situated on the reservation. If we lose the reservation status, we lose that school status. Our tribe suffers from having only a 51% high school graduation rate. Our language immersion school is vital to increasing our citizens' graduation rate and reducing substance abuse and suicide rates. We're not asking Congress to do something it has not already done before. In the 113th Congress, Congress passed the Gun Lake Trust Land Reaffirmation Act, which reaffirmed a prior trust acquisition for that tribe. Congress also enacted legislation for the Virginia tribes that expressly made the IRA applicable to them, just like the Mashpee Reservation Reaffirmation Act would do for us. H.R. 312 is supported by the town of Mashpee, the city of Taunton, and our state government. It also has wide support from Indian country, including the National Congress of American Indians and major regional pan-tribal organizations, as well as dozens of individual tribes. It also has widespread support from our local chambers of commerce and the Mayflower Society. We're aware that the state of Rhode Island opposes our legislation. The immediate damage that Carcieri versus Salazar did to the great nation of the Narragansett tribe, our sisters and neighbors in the first instance, and the broader damage that case inadvertently has inflicted on the rest of Indian country in these last 10 years has been terrible. Now the state of Rhode Island seeks to reach across the state line into Massachusetts to crush the hopes and dreams of my nation. Respectfully, we request that Rhode Island consider the gravity of its behavior and reconsider its position. We're grateful that the committee is considering H.R. 375, the Clean Carcieri Fix Bill. We strongly support this legislation, and we thank sponsors Representative Cole and Representative Betty McCollum. But with great respect, the impact of the Carcieri decision on our tribe is now immediate. And finally, since time immemorial, the Mashpee Wampanoag and the land have been inseparable. We have been on the land where Creator placed us, and this is true today as it was 400 years ago.
Vice Chairman, please wrap up.
I'm happy to answer any questions you may have.
Perfect. Thank you, Vice Chairwoman. The chair now recognizes Kevin Washburn. Mr. Kevin Washburn to testify.
Chairman, Ranking Member, Chairman Grijalva, Ms. Holland, who represents my former home, it's good to see you, and former Chairman Young, I've missed you these past few years.
Okay, with objection, I'm ruling that out of order.
I'd like to also thank Tom Cole, my cousin from the Chickasaw Nation, and Betty McCollum. First, I'd like to talk about H.R. 375. That is bipartisan legislation that both of them have pushed for quite a while, and it would be great to get this done. I won't repeat many of the things that Tom Cole has already said, and you've got my written testimony, but I just would like to make a couple of points about H.R. 375, the Carcieri Fix bill, and that is this. No member of Congress and no federal policymaker would design a system that has two classes of tribes for land into trust. We wouldn't, if we started from scratch, that's not what we would do. We would treat tribes the same. And indeed, in 1994, Congress passed legislation demanding that tribes be treated the same for all purposes under the IRA, the Indian Reorganization Act. So no one would have come up with this system from scratch, and we've been living with it because of an erroneous Supreme Court decision that frankly was not well thought out. You know, the question really is, should tribes recognized since 1934 be able to have housing? Should they be able to have police stations and fire stations and lands for agriculture? Should they be able to have economic development and infrastructure? And the answers to all those questions are, of course they should. During the Obama administration, the administration, I think, accepted something like more than 2,000 acres of or parcels of land in trust, encompassing well over 500,000 acres. And that's because those tribes needed that land, and that was really important to the Obama administration to try to make that happen. Perhaps the best part of H.R. 375 is that it would reduce a lot of unnecessary litigation and a lot of bureaucratic resources that are being wasted. And I'm dean of a law school. I'm all for full employment acts for lawyers, but that's really what H.R. 375 is. And frankly, there's plenty of work for lawyers in Indian country without having to do so much work to try to meet the requirements of Kacheri. So I think that we've got a lot more better use of work by the hardworking Indian lawyers in Indian country than to try to keep dealing with this issue. And you guys could correct that really easily by passing this bill. Since the 1990s, there has been a requirement that each year the federal government publish a list of tribes that are recognized. It would have been nice if we'd had that in 1934. That would have saved a lot of this work from tribes. But the fact is there is no tribe that exists today that did not exist in 1934. We don't create tribes out of whole cloth in this country. We spend a lot of time working on the reformation of that tribal recognition process, and those tribes have always existed, and so they deserve to have land if they've existed. So I would respectfully urge the committee to try to move H.R. 375 on through the House. Let me move briefly to the RESPECT Act, Chairman Grijalva's bill. I strongly believe in the need for consultation as a matter of law, as he described it. We have had at least 2 decades of careful policy making around tribal consultation. It's become a strong federal norm that tribes should be consulted on the matters that affect them. And it really has become part of the way we do business in the federal government with regard to Indian country. It's a norm that does not get applied evenly across administrations, however. And I actually, in some ways, don't like the RESPECT Act because it puts a lot of requirements in place before the federal government can act. And I guess I'm a little bit libertarian. I don't like putting a whole lot of additional requirements on the federal government because it'll also keep them from doing good things. That said, I think what we've seen is that we need something like the RESPECT Act, and I'm grateful for Chairman Grijalva for proposing it. There are a lot of good things that it does. One is that it forces consultation. Since it forces consultation, that means that it also wraps in independent federal agencies, such as the Federal Energy Regulatory Commission and the National Labor Relations Board, and those sort of agencies. I think that's important because those agencies have not always been good about consulting with tribes, and a president's executive order can't reach those agencies in the same way. Why don't I stop there? My time is about up, but I'll be happy to answer questions in a little while if need be.
Thank you, Mr. Washburn. The chair now recognizes Ms. Colette Rutel for her testimony.
Good afternoon. Thank you for allowing me to appear before you today to testify about H.R. 375, a bill to amend the Indian Reorganization Act. As you know, in Carcieri versus Salazar, the Supreme Court held that trust lands could only be acquired for tribes that were under federal jurisdiction when the IRA was adopted in 1934. Because the IRA is the only general statute that authorizes the Secretary of the Interior to take land into trust for Indian tribes, tribes that cannot make this showing face the prospect of never regaining a permanent homeland. Scholars and practitioners alike immediately decried the court's extraordinarily cramped reading of the statutory text and predicted that the decision would wreak havoc throughout Indian country by encouraging waves of litigation, stifling economic development, and creating dividing lines between tribes that Congress had sought to abolish. Sadly, those predictions have come true in the decade that has followed. Frivolous lawsuits have abounded. Local governments and private citizens have challenged the trust acquisitions of dozens of tribes that were obviously under federal jurisdiction in 1934. Litigants have also used lawsuits to challenge land that has already been taken into trust. For example, in 2015, a tax assessor in Alabama assessed property taxes on land that was taken into trust 30 years before for the Porch Band of Creek Indians. The tribe obviously won this case, but not until it had litigated it all the way to the 11th Circuit. Of course, not all Carcieri challenges are frivolous. In 2014, the Department of the Interior issued a formal opinion which provides a two-part framework for determining whether an Indian tribe was under federal jurisdiction in 1934. The problem is that finding and assembling the information necessary to satisfy this two-part inquiry is daunting. Federal records and correspondence needed to demonstrate these actions are scattered throughout the country in public archives and in private collections. And when tribes gather all of this documentation, they can do so only to have the rules suddenly shift. The Mashpee Wampanoag tribe find themselves in just this position. In September 2018, the department refused to reaffirm the status of the tribe's reservation, and it did so even though the Mashpee submitted documentation, for example, that showed the significant number of Mashpee children attended the Carlisle boarding school. Mashpee members were included on federal census rolls, and the federal government recognized the tribe's hunting, fishing, and gathering rights. This is all evidence that has previously been considered to be sufficient to withstand a Carcieri challenge. The consequences for Mashpee have been extraordinary. The tribe has broken ground on their casino and apparently owes more than $300 million. Yet construction is indefinitely stalled and the tribe has no more access to capital. Without trust lands, the tribe does not qualify for even the most basic federal programs, such as food distribution programs, burial assistance, and adult care assistance. All of these programs are administered for Indians that live on or near a reservation, and the federal government now tells the Mashpee that they do not. The Mashpee are just one example of why trust lands are so vital. They're the only lands that are permanently held for the benefit of an Indian tribe. Trust lands can't be taxed, they can't be condemned or otherwise alienated without tribal or congressional authorization. Trust lands are also the only lands on which tribes' sovereignty has never been questioned. Permanency and sovereign authority are necessary components for a true homeland for Indian tribes, and this can only be achieved with trust lands. As Dean Washburn already mentioned, there is simply no policy justification for using 1934 as a magical date that limits access to such an important benefit. Moreover, it's not even this date of tribal acknowledgement, but rather the manner in which an Indian tribe became acknowledged that has proved crucial following Carcieri. Tribes that were recognized by Congress are almost always insulated from the impacts of Carcieri through express provisions in the recognition bills that allow fee to trust applications. It's only tribes that went through the Office of Federal Acknowledgement's grueling recognition process that are now faced with never receiving any land into trust. Many of them waited years and expended millions of dollars to obtain acknowledgement as a federally recognized tribe, only to find that the benefits of that decision are illusory. I urge the members of this committee to support H.R. 375, which will once again clarify that the benefits of the IRA are available to all federally recognized tribes. Thank you.
Thank you, Ms. Rodell. The chairman recognizes Ms. Richards to testify.
Good afternoon, Chairman Gallego, Ranking Member Cook, and distinguished members of the subcommittee. Thank you for giving me the opportunity to speak in opposition to H.R. 312, the Mashpee Wampanoag Reservation Reaffirmation Act, and to talk a little bit about the Act's potential effect on Rhode Island. My name's Clare Richards. I'm Executive Counsel to Governor Gina Raimondo, the Governor of Rhode Island. I have served as legal counsel to 4 governors. 2 were Republicans, 1 was an independent, and Governor Raimondo is a Democrat. My 22-year tenure has included 10 years of litigation involving the Indian Reorganization Act, resulting in the Supreme Court's decision in Carcieri versus Salazar. In my capacity as Governor's Counsel, I regularly deal with complex legal questions surrounding the allocation of sovereignty between the state, the United States, and Indian tribes. Congress enacted the IRA to authorize the Secretary of Interior to take land in trust for Indians. By its express terms, however, the IRA authorizes such fee-to-trust conversion only for those Indian tribes under federal jurisdiction as of 1934. In 2015, the Secretary took land into trust for the Mashpee to operate a resort casino in Taunton, Massachusetts, even though the Mashpee were not under federal jurisdiction as of 1934. The Secretary's decision violated the IRA and was an effort to sidestep Carcieri. It was quickly struck down by a Massachusetts federal court in a case called Littlefield versus the Department of the Interior. Littlefield held that the Secretary's decision to take the Taunton land in trust was wrong based on the plain language of the IRA. Responding to the Secretary's argument that certain provisions of the IRA were ambiguous and therefore permitted her to convert the Taunton land to trust, the court replied, quote, "With respect, this is not a close call. To find ambiguity here would be to find it everywhere," end quote. The Mashpee Act resurrects and summarily affirms this erroneous interpretation of the IRA. In so doing, it undermines the established statutory scheme for acquiring trust lands for Indians, as well as the Supreme Court's decision in Kachiri. It nullifies Littlefield and upends the current view of the Department of the Interior itself. All conclude that the Secretary is not authorized to take land into trust for the Mashpee or any other tribe that was not under federal jurisdiction in 1934. The Act and the faulty rationale upon which it is premised will open the door to other fee-to-trust conversions in states like Rhode Island, whose tribes are also excluded from the trust provisions of the IRA. Federally recognized tribes in these states will argue that they stand in no different position from the Mashpee, and that the Secretary's discredited rationale should apply to them as well. Federal trust acquisitions can have serious consequences for states. They strip states of their jurisdiction over land, they encourage tax-free and tax-advantaged sales on trust property, and they give rise to complex jurisdictional checkerboarding issues. And the acquisition of land in trust is often a necessary precondition to the establishment of a federal Indian casino. Rhode Island would be particularly hard hit by such acquisitions, whether within the state or, as here, less than 15 miles from its border. As one example, Rhode Island's Constitution gives the state exclusive authority to operate casinos within its borders. Rhode Island operates 2 casinos and uses its over $300 million a year in annual gaming revenues to fund education, infrastructure, and social programs for its citizens. An Indian casino in Rhode Island's gaming catchment area poses a serious threat to those revenues. Rhode Island has also experienced similar threats to revenue from the sale of tax-free tobacco products on Indian trust lands. Because of their effect on surrounding jurisdictions, trust acquisitions should strictly conform to the plain language of and the limitations set forth in the IRA. They should follow an orderly and established vetting process, which includes consideration of the impact on neighboring jurisdictions. They should not be based on a firmly discredited legal rationale to which even the current Secretary of the Interior does not adhere. Thank you again for allowing me this opportunity to raise the Governor's concerns on this important issue and to urge the subcommittee not to pass H.R. 312. I'd be happy to answer any questions.
Thank the expert witnesses for their powerful testimony, reminding the members reminding the members that Committee Rule 3D imposes a 5-minute limit on questions. The chairman will now recognize members for any questions they may wish to ask the witnesses. I will start by recognizing myself for 5 minutes. This question is for the Honorable Jesse Little Baird. From your testimony, you seem to have a lot of local support for your tribe and your economic development initiative. What local support do you have, and why is there opposition from the state of Rhode Island, although I think I just plainly heard the answer? And does your tribe's bill affect the jurisdiction of Rhode Island in any way?
Thank you. I think the reason that we have opposition from the state of Rhode Island, we've just heard, fully a third of their state revenue is generated from their casinos, the state casinos. And our legislation has absolutely no impact on the state of Rhode Island in terms of jurisdiction taxes or anything else. We do have full support from our legislature, the city of Taunton, the town of Mashpee, chambers of commerce, and I think it's pretty clear that the reason the state of Rhode Island opposes our bill is because it wants to protect its current monopoly on the gaming industry in southern New England. It has been successful and using the courts to crush the Narragansett tribe, and it now is attempting to use Congress to do the same to Mashpee.
Thank you. Mr. Washburn, in your testimony, you mentioned the Patchak Patch, an administration policy that eliminated the 30-day waiting period for implementation of land into trust decisions. Although trust decisions can be challenged through administrative or judicial litigation, this policy allowed the land to stay in trust pending the outcome. What are the legal ramifications of not having this policy in place during the land into trust process? And do you know if the Trump administration has been receptive to implementing a similar policy?
Thank you, Mr. Chairman. So we instituted the Patchak Patch, so-called, during the Obama administration, basically so that land would go into trust immediately rather than waiting for 30 days. The reason we had the federal government originally waited for 30 days was to give people time to challenge that and bring litigation if they wanted to do so. What we learned was that it was really a delay tactic. People would challenge it, and litigation would go on for years and years, and that was just for purposes of delay. Ultimately, the United States would win that litigation, but meanwhile, the land would not have been in trust for as many years as litigation went on. So the Patchak Patch was a way to say, we're going to take the land into trust immediately, and if there's any litigation, it can happen while the land is already in trust. My sense is that the Trump administration is revisiting that approach that the Obama administration used, and they have been trying to do consultations and have discussions around changing the land into trust rules to make them less favorable for tribes. Thank you.
Thank you, Mr. Washburn. Ms. Rotell, other than the Mashpee, how many times have you witnessed a tribe face challenges to their fee to trust applications due to Kachari?
It's really hard to put a number on it because there are countless challenges that come at the application stage that never make their way into the courts. But when we look at challenges that have been brought in the federal courts and in front of the Interior Board of Indian Appeals, we're talking about some 50 reported decisions at this point. So there has been a large amount of litigation, and a lot of it has been litigation that, as Dean Washburn mentioned, we would consider to have been brought just to delay tribes that there is no doubt that they were under federal jurisdiction in 1934 because they appear on some of the very first lists that were created of tribes that allowed them to vote on application of the IRA and confirm that they either voted on and adopted or disapproved IRA constitutions.
Ms. Richardson, how many other casino or gaming enterprises has the state of Rhode Island opposed, either through litigation or through the legislative manner outside, obviously, Rhode Island?
To my knowledge, this is the only one, Mr. Chairman.
So this is the only gaming operation or in potential gaming operation that the state of Rhode Island has actively involved, even though we know are other operations that are either coming online or have come online. Is it because this is the only opportunity to have a legal recourse using the Kachari problem, and that's why you're not using it for other tribes, or are the other tribes? I'm sorry, are other gaming institutions better funded, be more difficult for the government of Rhode Island to fight them?
No, this is an act. The Mashpee Reaffirmation Act is an act that has a direct economic impact on us, and that's why we're here today. Right,
but there are other gaming institutions that also will have a direct economic impact on the state of Rhode Island. Has your representation for those institutions, has the state of Rhode Island ever opposed legally in any manner any of those other gaming institutions?
You mean private casinos?
Yes.
We have not opposed any private casinos to my knowledge, and the reason for that is that private casinos operate on a more equal footing to Rhode Island's casinos. It's much more difficult for Rhode Island's casinos to compete against a federal Indian casino because of the effective tax rate.
Find that a very dubious claim. Thank you. And I'd like to recognize our ranking member, Representative Cook.
Well, thank you very much. I appreciate the witnesses. And just to carry on, Ms. Richards, on the competition from other casinos, if you will. And that's kind of I think, the argument here. You do have two in Connecticut that are very close to the Rhode Island border, right? And I noticed they weren't mentioned in the threat to the commercial interests of Rhode Island. Obviously, it's just the Mashpee, is that correct?
The two Connecticut casinos, which are the Foxwoods and Mohegan,
yep.
They're not far from the Rhode Island border. On the other hand, they predate any, they certainly predate my time in office. They predate Kachiri, and they may even predate some of our own gaming operations.
You know, I got to be honest with you. I'm very sympathetic to the tribe in Massachusetts. And I could get myself into serious trouble because, you know, I usually drive from Connecticut to Cape Cod in the summer, and I'm sure I'm going to have a number of speeding tickets going through Rhode Island if I don't handle this correctly. And secondly, my daughter and son-in-law are both graduates of the University of Rhode Island, so Thanksgiving is going to be a very interesting time this year. But in the testimony that was given, you know, I understand commercial interests and everything else, but as you know, somebody who taught American history, I'm very, very sympathetic to tribes and their own identity, and far too often I think so many tribes have been on the verge of extinction because of some of the things that have happened in the past. So I'm from California. I know the wars between casinos and gaming and everything else. But I still think I have a tendency to side with the history, the heritage, and everything else. Gaming maybe transcends things. So right now I'm very, very sympathetic to the testimony that was been given by the Mashpee Indian. I yield back.
Thank you, Ranking Member Cook. Now I recognize Chairman Grijalva for questions.
In response to the chairman's question, you answered the direction in which I wanted to ask you as well. But Ms. Richards, let me just follow up on some questions. After the Kachiri decision in 2009 that involved the tribe in Rhode Island, ultimately this decision led to the Supreme Court ruling that land cannot be taken into trust for tribes recognized after the Indian Reorganization Act in 1934, which brings us to today and brings us to Mr. Cole's legislation. Why do you believe that land is only afforded to tribes recognized before 1934?
To be perfectly honest, Mr. Chairman, I don't really think there's a great reason why there should be two classes of tribes, those under jurisdiction prior to 34 and those under jurisdiction after 34. So for that reason, I have not testified against Representative Cole's bill, which is H.R. 375. That would extend the Kachiri, that would extend the IRA to all tribes, regardless of when they were under jurisdiction. I think the state of Rhode Island, you know, if that bill were to pass, I think the state of Rhode Island would really urge a total revamp of the IRA. And the revamp would include setting standards for the acquisition of tribal trust property, for taking into account the impact of trust property on local jurisdictions, for making a system that is transparent, which has clear and objective standards, gives local jurisdictions significant role in the process, a substantial role in the process, gives timely notifications to jurisdictions.
Essentially providing to, in this instance, the state, some degree of veto power over a land being taken into trust, correct?
Some degree of consultation, just as you, Mr. Chairman, seek full consultation between tribes and the federal government, the state and local jurisdictions would also seek to be heavily involved. I think one of the things that
so you don't see Mr. Keating's legislation as complementary to the position that you just said that you don't think there should be two standards of tribes.
I do not see it as complementary, no.
And in correcting what is essentially a precedent that does establish two different standards for tribes, particularly the issue we're dealing with of land being taken into trust.
I think Mr. Cole's bill, H.R. 375, would address the parity issue between the pre-34 Act tribes and the post-34 Act tribes. But I don't think, but I do think a total revamp of the IRA to be more responsive to states' interests would be called for.
I think that would be a significant, and I think undercutting of sovereignty and trust responsibility if we were to establish a precedent that essentially, whether you want to call it consultation, but would provide a state or another local entity, a municipality, a county, essentially veto power over a process that is devoid of those other interests.
I don't see it as veto power, but I think it is very important to keep in mind the host jurisdictions' impacts that arise as a result of a fee-to-trust acquisition.
Tomato, tomato, but I think it's veto power. Let me yield back, Mr. Chairman, and appreciate the time.
Thank you, Mr. Chairman. And we now recognize Representative Keating.
Thank you, Mr. Chairman. Attorney Richards, you broadened your arguments in your remark to say, basically, that all states should be concerned about this. I just want to ask you, we tailored this bill directly from the legislation in Gun Lake and the Virginia tribal legislation. So if this is such a concern to all states, did you take any formal opposition as a state to those two pieces of legislation?
We did not. I am not familiar with those pieces of legislation, unfortunately.
I would tell you that they're almost identical to this legislation. And do you happen to know how the Rhode Island congressional delegation voted on the vote on one of those bills?
I do not know.
I'll inform you. They were in support of those bills. So the congressional delegation from Rhode Island supported the very same legislation as this. Just another question. Your background in law is one of jurisdictions, and you mentioned state jurisdiction and U.S. jurisdiction. You can clearly, I think, can't you, know the boundaries and jurisdictions of a particular state?
I do know the geographic boundaries of the state. I certainly am aware of those. Could you say you can define the boundaries of America, of the United States? I don't really think I understand your question.
Do you believe that America, the United States, has a boundary around it?
Yes.
Thank you. So I have a question for you. Can you define what you included in your testimony? Can you define this entity? You said you defined an entity as the Rhode Island's gaming catchment area.
Yes.
What's that jurisdiction?
What
does that mean?
Normally, when people discuss gaming, Indian or any kind of casino, they draw a circle around the casino.
What's a circle?
It's a certain geographic circle.
What is it, though? You're here.
I think it's about 100 miles.
Is it? So that's official boundary? Well, the question then, are you aware that Massachusetts already has approved a casino in that southeastern Massachusetts area, regardless of this?
I am.
So what you're saying is you don't want this particular piece of legislation that will keep a tribe in existence versus another one that's already approved by Massachusetts that you can't do much about. It's going to have the same effect, if not more, on your gaming. So how could you do this to the tribe?
Because, as I explained earlier to the committee, Indian gaming operations do not operate on an equal footing from private casinos.
You're missing my point here. There's still going to be a casino there.
That's
So,
right.
and you're saying the biggest reason you're here is Rhode Island's going to lose money for those Massachusetts plates that come over the border.
What I'm saying is that there are impacts on Rhode Island from having fee-to-trust conversions. They're not limited to casinos. They also include the tax-free and tax-advantaged sales of any product. Those tax-free and tax-advantaged sales from trust properties affect Rhode Island very clearly, even though they may not be located.
So you're in
within its
favor of a
borders.
casino from Massachusetts on the other side of the border then?
Pardon me?
Then you're in favor, if that's your point, then you're in favor of a casino on the other side of the border, just not this one. So Rhode Island's position, the governor's position is that you favor a casino in southeastern Massachusetts.
We
next
are
to your border.
neutral on opposing casinos that operate under the same competitive footing as
So
Rhode
just for
Island's.
the record, it's good that the Rhode Island people know that you're not opposing a casino on the other side of your border and the revenues that might be lost according to your arguments. I yield back.
Thank you, Representative Keating. Further questions for Ms. Richardson. Has there been an economic impact study, not on the gaming side, but on what you claim is going to be the impact of sales of tobacco and other non-taxable goods on the state of Rhode Island?
I am not aware of a study that we have because we haven't confronted this. In 2002, the Narragansett Indian tribe started the tax advantage sales of tobacco products from trust lands within Rhode Island, and the state took immediate action, but we did not have an impact analysis done.
You do understand why, just 1 second ago, you said, well, the other reason why we are against this is because of non-taxable goods such as tobacco sales. And then when I asked you, have you done a study what that would be impacted, you said you don't know what the impact would be. So, you know, it makes it very difficult for me to understand your position. So if you don't understand what the impact is, how could you say it's actually going to affect Rhode Island? You're just guessing.
Well, the differential between taxed tobacco products and untaxed tobacco products is enormous, and I think most people would
Enormous in
choose-
what sense? Are we talking a couple 100,000, million, 2 million, 10 million? You don't know, but yet you're coming here and testifying and somehow making a decision, not you, but obviously at the behest of your government, that is a reason why to stop the Mashpee from actually having recognition. I mean, what I'm saying is if you're going to come here and say that, at least have a claim with some money and a study attached to it.
We have experience from our own jurisdiction. We haven't done a study because we don't have tax-free or tax-advantaged sales going on right now, but we did in 2003 have them, and we determined for ourselves that it would be a serious impact on our tobacco revenues. I cannot, at this moment, give you the exact amount of the impact.
But you can feel comfortable enough to use as an argument to stop this tribe from being federally
Yes,
recognized.
I can.
Ranking member. Representative Gosar.
Thank you, Mr. Chairman, and Republican Leader Cook for allowing me to participate in this important hearing today. I'm especially grateful to Mr. Cook for his leadership on the subcommittee and on these issues. The so-called RESPECT Act is an extremely radical proposal that would shut down important operations within the federal government until the lengthy and unrealistic consultation and coordination requirements prescribed by the bill are met. It is so broad and far-reaching that even the Obama administration opposed a nearly identical version of this bill. This bill would cause catastrophic harm to local communities and increase things like permitting times, negatively impacting grazing, responsible energy production, forest thinning, and important infrastructure projects in that process. We all want tribes and local communities to have a way in which activities that impact their daily lives, but this bill isn't the way to go about that. A better model is the provision in the La Paz County Land Conveyance Act that I worked on with the Colorado River Indian Tribe to include. H.R. 375, the so-called clean carcerary fix, is another bill I oppose in its current form. H.R. 375 contradicts a Supreme Court ruling and the Indian Reorganization Act of 1934. We have seen previous departments of interiors take off reservation land into trust against the will of states, compacts, and local communities for the sole purpose of building new casinos. This was certainly the case in my state with the To'ota O'odham Nation, who covertly acted against its fellow tribes, the state of Arizona, and the general public to open an off-reservation casino in Glendale. Litigation discovery and audio recordings affirmed this shameful conspiracy implemented by the TO. I am concerned that H.R. 375, as written, will encourage the same future abuse in that regard. Finally, H.R. 312 is contrary to current view of the Department of Interior, contradicts a Supreme Court decision, and aims to reverse federal court decisions on this matter in order to build a massive 400,000 square foot off-reservation gaming complex for the benefit of a Malaysian gaming company. Besides benefiting this Malaysian company, H.R. 312 has close ties and origins associated with corrupt D.C. lobbyist Jack Abrahoff and Senator Elizabeth Warren. The Mashpee tribe paid tens of thousands of dollars to Abrahoff, and the chairman of the tribe at that time was sentenced to 41 months in prison for crimes he committed in conjunction with efforts to secure federal recognition. The Mashpee tribe was not a federally recognized tribe until it received an administrative recognition in 2007. If H.R. 312 is passed, Congress will declare years of fighting and victories by local stakeholders as if they never happened. Congress will also take the view that current federal law shouldn't apply to the Mashpee tribe. Now, Ms. Richards, you testified that if this massive 400,000 square foot off-reservation gaming complex is allowed to be built in Massachusetts, the state of Rhode Island will suffer significant harm with regards to revenue for education, infrastructure, and social programs. Can you elaborate a little more on this harm and reiterate why the governor and people of Rhode Island oppose this bill?
Mr. Gosar, we have conducted an impact analysis which I can provide to you. I'm not familiar enough with the contours of that to talk about it at the moment.
We'd appreciate that. Vice Chairman Baird, how will the tribe ever make money from this casino project in light of the $450 million debt that the tribe owes in Getting, which would operate the casino? Is this bill actually a financial bailout for Getting?
It's Vice Chairwoman, Representative. And I would first like to state that for me, as a Mashpee Wampanoag woman, mother, grandmother, and a leader of my community, and as a woman whose blood and bones have been in my territory for 12,000 years, I am sitting here today with one purpose in mind: to keep the land under my people's feet. I also want to state that because the federal government has forced this tribe and other tribes into two processes that are very lengthy and very expensive. One, the federal acknowledgement process, and two, the land and trust process, for which the federal government provides no funding to assist tribes. We are forced to enter into agreements and find funding to help us get through these processes. And they're very expensive. The federal acknowledgement process alone took 30 years and cost us millions of dollars, as did the land and trust process.
Well, I find that, Mr. Chairman, a little obvious at
Thank you,
debt service being over $350 million that you'll never get out from underneath that debt. So I yield back.
Thank you, Representative Gosar. I'd now like to recognize the Chairman, Rural Grajava.
Thank you very much. Dean Washburn, if Congress does not act on righting this wrong custodiary decision, what do you foresee in the next 10 years of having this type of decision on the books for Indian country?
Chairman, it's just going to keep causing problems. It's going to keep causing litigation. As my colleague Professor Rutel testified, it gets brought up in a lot of these cases and has to be litigated. And you need expert witnesses to go out, historians to go out and gather up a bunch of documents. And kind of like Vice Chairman Woman Baird was just talking about, these experts are very expensive and they end up causing tremendous delay. And it means that some tribes may never get land in trust, and that's really the problem. And every tribe deserves to have a homeland.
Professor, the same question from your perspective. If we don't do this clean fix that is before us,
I think we will. The starkest example, is really the tribes that were recognized through the OFA process that spent 20, 30 years to gain that recognition, that expended enormous resources. And in all those cases, they had to prove, sometimes from historic times all the way to the present, that they continued to exist. They had to prove that they continued to exist socially and politically, that outsiders recognized them. They had to amass an enormous quantity of documents. And yet, after standing in line and going through that whole process, they're now faced with never having any land into trust. Meanwhile, other tribes that were in similar position were recognized by Congress, and they all received language in their recognition bills that specifically allow them to receive the benefits of the IRA and some of the mandatory trust acquisitions. What Ms. Richards was saying about tribes, like the Mashpee being tax-free is this is a myth in Indian country. Native people pay taxes and tribes do. The federal government taxes Indian gaming operations. And there are taxes that flow. It's just they won't flow to Rhode Island because of those borders. But the Mashpee have, they'll create 7,000 new jobs. They'll give $50 million in revenue to the state of Massachusetts. In addition to that, there's $100 million in revenues that's projected to go to the city that the casino is sited in. And this notion of tobacco taxes, the Supreme Court has repeatedly held that tribes, when they sell tobacco to non-natives, they actually have to collect a state tax. So again, there will be a tax on those sales. It's just the tax will be turned over to the state of Massachusetts. So the tribes are not in a competitive advantage here. Mashpee just wants what every single other tribe has in the country, which is a permanent homeland.
and the compact with Arizona, all the 22 tribes and those that do have gaming as part of their enterprises, pay to the state. That revenue goes into, unfortunately, into I think is a black hole, but that's another story. Mr. Chairman, with all due respect, I have to leave for amendments on the floor. The next panel was to discuss the Respect Act. I apologize for not being here for those questions. I will be submitting those in writing to you to forward, and to the other panelists that are going to speak to that issue. My apologies. I need to be there. I thought this would go faster than it did, and I yield back, and thank you very much.
Thank you, Mr. Chairman. If there are no further questions, we're going to move on to the second panel. All right, excellent. Okay. Let me again remind the witnesses that under our committee rules, they must limit their oral statements to 5 minutes, but it does not have to be 5 minutes. But that entire statement will appear in the hearing record. When you begin, the lights on this witness table will turn green. After 4 minutes, the yellow light will come on. Your time will have expired when the red light comes on, and I will ask you to please complete your statement. I will also allow the entire panel to testify, minus Mr. Washburn, who already gave his testimony before questioning of the witnesses. Our first witness is going to be Ms. Vanessa Ray Hodge, partner at, apologize if I said it correctly, Sanoski LLC, and former senior consultant solicitor at the Department of Interior. And finally, Mr. Matthew Fletcher, professor of law and director of Indigenous Law and Policy Center at Michigan State University College of Law, as well as, again, Mr. Kevin Washburn. The chair now recognizes Vanessa Ray Hodge to testify.
Good afternoon, Chairman Gallego and members of the subcommittee. My name is Vanessa Ray Hodge, and I am an enrolled member of the Pueblo of Acoma and a partner in the law firm Sonosky Chambers. I regularly represent Indian tribes throughout various tribal consultation processes. I previously served as the senior counselor to the solicitor at Interior and actively participated in numerous federal tribal consultations and in the development of Interior's tribal consultation policy. And I have to say, from my experience at Interior, tribal consultation doesn't necessarily slow down the federal process if it's done right. I support and applaud Congressman Grijalva's bill, which would codify the principles of Executive Order 13175 into law and establish a legally enforceable consultation obligation for all federal agencies. The United States has a long history of enacting policies or authorizing infrastructure development projects over the objections of tribes, which has often resulted in the destruction of tribal communities and culture. Tribal consultation is implemented differently by each executive department, and the sad reality, especially now, is that tribal consultation is often treated as just a box to check or completely ignored. But Executive Order 13175 was intended to treat tribes as sovereign nations and recognize that the United States had policies in the past that placed tribes on reservations, oftentimes removing them from their Aboriginal homelands where many tribes continue to have treaty rights and cultural and sacred sites. The ad hoc manner in which consultation is implemented by federal agencies has resulted in frustration by Indian tribes and widespread discounting of tribal governments and their concerns. This has created an adversarial process rather than a cooperative one in which tribes are seen as valued partners that can improve the decision-making process in a manner that respects tribal rights. The RESPECT Act takes a major first step towards changing the tribal consultation process in a good way. The Act outlines a structured process that aims to ensure that tribes can participate fully in consultation, and consultation must occur early and often. In my experience, I have often found that there is a lack of federal decision makers who are directly involved in consultation. Instead, agency staff often attend and they are not authorized or able to answer questions or provide meaningful feedback to Indian tribes. Tribes are left having a one-sided dialogue and are usually only informed about how their concerns were addressed after a final decision is rendered. The RESPECT Act would bring a much-needed change in this process by requiring a two-way dialogue between federal agencies and tribes. An important component that would also help improve the consultation process is to require training for federal employees who participate in consultation and to agency decision makers. A core objective of tribes during consultation is to provide federal decision makers with context and information needed to support informed decisions that protect tribal interests. Tribal concerns are often misunderstood or overlooked by those without any background in the unique history and relationship that the United States has with Indian tribes. With the right tools, consultation can provide a solid foundation for federal decisions, but federal agencies must recognize and apply these principles. Where federal actions relate to applicants seeking federal approval for a project, the consultation process should also require that applicants meet with, consider, and address tribal concerns. There should not be an expectation that applicants can ignore tribes and just work with federal agencies, and federal agencies shouldn't be able to hide behind applicants. When all parties come together, I have seen positive working relationships result, even when it requires modifications of a project. And while there may not always be agreement, federal agencies have a trust responsibility to take a hard look and deal with tribal concerns. In this regard, the Act should specifically recognize federal agencies' affirmative obligations to protect tribal treaty resources, sacred sites, and trust lands. Indeed, in 2016, 9 federal agencies signed an MOU recognizing this obligation must be considered when making federal decisions impacting tribal interests. The goal of making tribal consultation judicially reviewable is also a critical component for accountability. In sum, the Draft Respect Act is a welcome piece of legislation that is long overdue. I appreciate the opportunity to provide these comments and would be happy to answer any questions you may have.
Thank you, Ms. Ray Hodge. The chair now recognizes Mr. Matthew Fletcher for his testimony.
Thank you very much, Mr. Chairman and Minority Leader. My name is Matthew Fletcher. I'm a citizen at the Grand Traverse Band of Ottawa and Chippewa Indians, which is located in Michigan. And I'm disappointed to see that Mr. Grijalva had to step out. I was about to engage in a little bit of hero worship. My very first trip to Washington, D.C. as a lawyer was in the late 90s, right around 20 years ago. And we were here to engage in an act of tribal consultation, so to speak. Back in those days, the Department of Labor's Wage and Hour Division had refused to treat my client, an Indian tribe in Arizona, as a state for purposes of minimum wage law. Our fire department and our police department, where fire department in particular would be on call for 48 hours at a time, and then they would get 2 days off, and then they would get another day on. And so they were, the Wage and Hour Division was telling us that we owed them 25 hours of overtime every week, even though most of the firefighters, although they were looking for the windmill, had to admit most of the time they spent in the fire station was lifting weights. So I got a chance to meet Mr. Grijalva that day, or that year, and talk about this project. That was a bad experience in terms of tribal consultation, but I've had some good experiences as well as a lawyer and as an advocate. Under the Obama administration in particular, we were pleased to see, especially when Mr. Washburn was Assistant Secretary, the government worked hard with Indian tribes, and they sort of were forced to by the Administrative Procedures Act in engaging in some regulation and guidance releases in relation to the Indian Child Welfare Act, which is a statute near and dear to my heart. And to be frank, that statute, while there's a little bit of litigation going on in that case, the regulations that came out and the accompanying guidance is some of probably the best work that has come out of Indian country in relationship to with the federal government that I've seen in the last 20 years. Outstanding work, and I think that's because the tribes were on board, they participated, and the federal government took what they said seriously. But when it comes to bigger projects where there are other issues, other interests that are arrayed against tribes or in opposition to tribes, I think what you see is the perception, without a statute like the Respect Act, with the perception from Indian country is always going to be that the federal government's practice is to consult when they want Indian tribes to help back them up with a project they're already going to go forward with. And then the tribe's perspective is that the federal government will not consult or will do a poor job of consulting when the federal government expects opposition from the tribes. And I just want to hearken back to the history of my own tribe, which is the Grand Traverse Band, and some of the tribes in Michigan. Way back in the day, in the 1830s, we came to Washington, D.C. to negotiate the Treaty of Washington, and our tribal leader back in those days was a guy named Mashpee. And he negotiated, along with the other Michigan, Ottawa, and Ojibwe tribes, a treaty that would guarantee us a homeland, that would guarantee us places to go on and off the reservation for purposes of hunting, gathering, fishing, obviously fishing. And, the Article 13 of that treaty says that we were allowed to enter off-reservation lands until those lands were required for settlement. And unfortunately, the first thing that the United States did with those ceded territories, they were never really settled, was to turn to lease those lands over to timber interests. And most of the lower peninsula and all of the upper peninsula of the state of Michigan over the next several decades were deforested. Possibly the greatest source of virgin pine in the Great Lakes is all gone. Some of that's still at the bottom of the Lake Michigan because of logs that have because of timber that is of ships that have sunk in Lake Michigan. But when we talk about catastrophic impacts as a result of actions taken by the federal government, I begin with my own tribe's history in this deforestation. That was our livelihood, those forests, and our access to those livelihoods until the land was required for settlement were destroyed. we were not able to really live in a homeland without access to those treaties. And you can see that throughout Indian country where there has been a history of a lack of consultation. You see the flooding of reservations at 3 affiliated, Fort Berthold, Seneca Nation, and other flooding of reservations. You see dams and culverts that have destroyed salmon habitat in the Pacific Northwest. And I guess I want to conclude with just to harken back to paraphrase to a Supreme Court case that just came out in Justice Gorsuch's dicta, mentioning that Indian tribes, when they negotiated treaties, did not just negotiate for the right to continue to live, but to continue to live in their way. Chimiigwech, thank you very much.
I want to thank their expert witnesses for their testimony. We'll now move on to questions. I'll start by recognizing myself for 5 minutes. Ms. Vanessa Ray Hodge, can you elaborate on how the RESPECT Act should be adjusted to protect all tribal treaty resources, sacred sites, and trust lands, and why is this clarification important?
I think it's important to have express mention in the Act because often agencies don't give serious consideration to their dual legal obligations, on those obligations under their federal statutes, but also to Indian tribes under treaties and federal case law. And so I think oftentimes what happens is because it's not in the top of the minds of federal agencies when they're resolving issues, tribal rights are often subjugated, are left out of the balancing of what is the right decision to make, or if modifications need to be made in a federal policy or a project to protect those rights. Because at the end of the day, it's only Congress that has the authority to diminish tribal treaty rights or rights that have been legally recognized by the federal courts for tribes. And so if agencies have to take that consideration into play, or else they could start trying to diminish rights that would be unlawful.
Thank you very much, Ms. Ray Hodge. Mr. Washburn, this version of the RESPECT Act was expanded so it applies to independent federal regulatory agencies. This was due to conversations with tribes that independent agencies were ignoring their duty to consult. What is your experience in your past dealings with some of these independent agencies when it comes to these matters, and should they be included in the RESPECT Act?
Thank you, Chairman. I would say absolutely, and that is something that only Congress can do because, President Clinton did an executive order on tribal consultation, and Obama did a presidential memorandum to further that. But the executive branch can't reach independent federal regulatory agencies like you all, and so we need Congress to act in the RESPECT Act for that purpose. And those independent agencies have a very checkered history of working with tribes. Some of them do okay sometimes, but they don't have that norm firmly established. And if you passed a law, they would have to follow that law. And I think we would get better results. Indian tribes work a lot better when the federal agencies communicate with them well. And Indian tribes and the federal government can work well together. We've seen that. But it takes careful consultation and good communication, and that's what the RESPECT Act does. Thank you.
Thank you, Mr. Washburn. Mr. Fletcher, thank you for your in-depth written testimony, especially your analysis of how drastically different things might be today for Indian country and America had tribal consultation been applied from the beginning. Where do you feel the duty for tribal consultation stems from?
Well, I think it's actually a constitutional duty, and it's certainly rooted in the treaties. You may recall that there are as many as 400 treaties between Indian tribes and the United States. And those treaties really are the creation of a relationship between governments, that is, a partnership. As Rob Williams wrote in his book, Linking Arms Together, on the history of the Haudenosaunee treaties, that some of the tribes treated those as familial relationships. And we know the Supreme Court in the Marshall Trilogy, which is the first series of important cases on Indian law from the 1820s and 30s, referred to this relationship where the United States had undertaken a duty of protection to Indian tribes. Most of those treaties referenced Indian tribes coming under the protection of the United States. And to this day, that duty of protection really is usually described as the general trust relationship. And if we treat these management of resources, management of government and jurisdictions as a partnership, then every single time the United States does take an action or propose an action that affects tribes, there should be some consultation with that partner, that tribal partner.
Mr. Fletcher, to follow up, consultation is inherently a government-to-government function, but there are times when the federal government delegates their powers to a state government for a particular purpose, such as implementing the Clean Water Act. Then the obligation to consult gets murky. What should the requirement to consult be in these cases?
Well, I think if nothing else, Congress could certainly require the states, when they do agree to implement federal programs through a delegation from Congress, that the states need to be reminded that they have also entered into, they're stepping in the shoes of the federal government, and they've entered into obligations under this trust responsibility. I look at some of the programs that are some of the activities undergoing in the Great Lakes right now, like the Back 40 mine, which is depending on Michigan approvals. We've also had the Line 5 in the Straits of Mackinac, which is a huge pipeline that literally could be is an existential threat to the Great Lakes. And all of that is dependent on, much of that is dependent on state action.
Thank you, Mr. Fletcher. I now recognize the ranking member, Representative Cook.
Thank you, Mr. Chairman. You know, listening to the testimony and everything else, I'm optimistic about this, but maybe it's my cynicism because of my old age and insults from Don Young. No, this is something. It's very, very difficult. I was in work for the federal government and the Marine Corps 26 years, and it seems as though every year there was a new program that we were going to change the Marine Corps, this and that. And one of the hardest things is to get it right in any of these programs, and it's going to be tough because I think we've got to change the behavior of the federal government, and particularly their attitude with Native Americans, indigenous people, because I think, I'm not a member of a tribe, but I would have a chip on my shoulder. I mean, if you look at all the history over the years, I'd be very, very careful of anybody from Washington. I don't trust them. But if you can have a level playing field, and I think you've got to establish, if this isn't enacted, and I think we got to go even further, so that you have the ground rules, what you want to accomplish. So it's not a Washington tells the tribes what's going on, or I think there's going to be resentment and failure. And I wanted to get Professor Washburn's, as a member of the previous administration, am I being too cynical? Because I think it's a great idea, good intentions, everything like that. But when you put it in action, it's going to be very, very difficult. Do you have any words of wisdom on where we can go a little further on this?
I think tribes and the federal government work better. They've improved over time, and they can work well together now. So I think maybe you are a little cynical. I think that we can be optimistic. Tribes have become so much more sophisticated and so much more capable of self-government and exercising sovereignty so much better and so much better resourced. And they've become almost equal partners to the federal government. There's still some paternalistic aspects to it, but tribes do a great job. And I think that largely the improvement is due to tribes, not due to the federal government.
Oh, I agree with you 100%. And maybe you trust the federal government more than I do, but I guess I shouldn't say that. I know we are, but I don't trust myself. And I think when, wait a minute, I got two. Thanks, Don. So all I'm saying is, and I was, obviously, I taught American history, a professor and all that, and maybe that's the problem. I taught too much American history, and a lot of it was terrible. And I'm not going to go through everything that's happened in so many different tribes. So all I'm doing is, I'll have an open mind on this, and I appreciate what the chairman's doing. And just starting off with the name of the act, the Respect Act. And this is something that hasn't happened for years, because if there was that respect then I think we could expect better conditions and everything else. So I'm not going to go on and on. I think we can do a lot with this. But the one thing I want is not driven so much by us, but you got to have that input from the tribes, a lot of different areas and this and that's going to be tough to find a common denominator. But let's do it. I yield back.
Thank you, Ranking Member Cook. I now recognize Delegate San Nicolas for questions.
Thank you, Mr. Chair, and I appreciate everybody being here today to discuss this legislation. I'm the delegate from Guam, and so I'm representative of the U.S. territory, and I'm also my heritage is Chamorro, indigenous people of Guam, and so we have a lot of close ties to our land as well, and a lot of the same challenges that our indigenous brothers and sisters have in the tribes as well. One of our most unique experiences so far has been dealing with a military realignment into Guam from Okinawa, moving thousands of Marines into the island. And one of the biggest challenges has been trying to walk that middle ground with the federal government in terms of the environmental impact on the territory. And one of the real advantages that we've had as a result of the process, the way the military needs to go about doing their process, is they were required to complete an environmental impact study before they can even move forward. And so one of the things I appreciate about this legislation is it creates a mandate for agencies to consult with the tribes. But I think that we need to maybe look further into creating a basis for consultation. For example, I think the tribe should probably be able to request in advance, prior to even beginning consultation, that an environmental impact study be done with respect to whatever activity the federal government is looking to undertake. And one of the reasons why I would probably recommend that is because if you require an environmental impact study up front before the consultations, then you'll have a basis for being able to go in and actually consult. Otherwise, you might be sitting down at a table and you're only discussing what they share with you. You might not have all the facts in front of you. And if there is no EIS, no environmental impact study, then you might not know necessarily what to consult about. And one of the most powerful things about the EIS that has been effective so far is whenever there was any violations of it, we could take the military to court and get the project stopped or get injunctions on whatever activities they're taking because their EIS, which was mandated to be presented before they were able to move forward, their EIS did not include a certain component. And so this might actually put more empowerment into the tribes if before there's even consultation, an official federal environmental impact study needs to be presented with respect to whatever activity, if the tribe so requests one to be provided in advance of consultation. Because I think a lot of the concerns at the tribal level will be similar to the concerns of the Chamorro people with respect to environment, it's respect to how you're impacting our way of life or how you're impacting our quality of life. And all of that had to be put into the environmental impact study that the military had to put together before they began moving forward with the military realignment. How does the panel feel about perhaps including some kind of component like that so that when you walk into these consultations that the mandate does require, you actually know what you're going to be consulting rather than sitting there and wondering if they're sharing all of the information or not, or if you're walking away from the table being fully informed and also being having fully participated based on all the facts. If I could get feedback from the panel, please.
Delegate, there's a lot of sense in what you say because tribes do need to have a lot of information to be able to consult effectively. I would probably stop short of requiring a environmental analysis or EIS before consultation can even start. I would come at it a little differently, just to say the federal government should consult early and often, and they should continue the consultation as more information becomes available, because I wouldn't want to put up an artificial barrier to keep the federal government from consulting with the tribe about something that it's going to be doing. I used to joke that, tribes would get mad at me when I was in the government if I came up with an idea in the shower and I didn't consult before I toweled off. The tribes want to have that much, they want to be engaged that much, and so if the proposal that you suggest, the only worry I have about it is that it would keep the federal government from going ahead and consulting while they're waiting for the EIS to be completed. Thank you.
Thank you, Congressman. I sort of agree with Mr. Washburn, but because I do think that tribes want to be consulted as early as possible when they know something's happening. I do think if it's something like an agency policy, you wouldn't necessarily do an EIS, but there are lots of projects that happen on federal lands where an EIS is required, and what tribes are asking for in the lower 48 and in Alaska is to be cooperating agencies from the start of that EIS document being started to the end of it, so that they have the opportunity for true consultation to get their concerns in.
Thank you, Delegate San Nicolas. Are there any further questions from the panel? Great. I thank the witnesses for their valuable testimony and the members for their questions and time. Members of the subcommittee may have some additional questions for the witnesses, and we will ask you to respond to those in writing. The hearing record will be held open for 10 days for these responses. If there's no further business before the subcommittee, the chairman again thanks the members of the subcommittee and our witnesses. The subcommittee stands adjourned.